But what we've seen is a huge explosion, pretty much globally, of lawyers in all sorts of cases using precedents, which are not precedents at all, which are fake. This is going to be with those lawyers forever. It's just an absolute scarlet letter on a lawyer's reputation. Hello and welcome to the next episode of Beneath the Law. Stephen Teal, sunny day, chilly in Canada though for May.
It's still chilly, Gavin. It is sunny, but I'm still wearing a coat.
We're old enough to recall, and I'm old enough to recall, the advent of the internet. Believe it or not, a lot of our listeners go, "What? There was a time when there was no internet," and I recall like the 80s when the computers started, and then all of a sudden the internet came along in the 90s, and it totally changed the landscape of everything, and the practice of law for sure. Because I remember when we went to law school, dude, that crazy place, we used to go to the place called the library, all these things called books, and you have to go in there. And I was thinking the other day, like even like silly things like a phone book. Talk about a generational reference. When's the last time anybody looked up somebody's phone number in a phone book?
Do phone booths still exist?
No, phone book. A phone book.
Yeah, I know that, but do phone booths still exist?
Well, yeah, because they used to have phone books in the phone booth. Remember, they used to be in those little plastic covers, and they used to pull them out.
Yeah, I know.
Phone number. In any event, so now we are into the next generation of revolution. I think it's going to be even more impactful than the internet was, and that's artificial intelligence and the advent as it exponentially replicates and grows. I think it's going to change everything, particularly the practice of law.
Everybody's trying to get into the business of artificial intelligence, Gavin.
Reminds me of the .com bubble.
Yeah,
remember that?
Exactly.
Everyone was a .com bubble. It was like every stock was a .com. So here we are. Here we go all over again. It's amazing, no matter how many times things are new, they're the same old, just with a different label. But for the practice of law, I recall, when first off, there was the internet searching of case law, and it was looked at quite askew by the bench, by law professors. They didn't like it, and you had to check your online searches against the print version, make sure they were correct. I don't know if you remember those days, but
you had to provide the print version to the court.
Yeah, they wouldn't take the online version. Now we live in the age of hyperlink, where the court's got the cases baked right into the factum. But before, we used to file these things called briefs of authorities, which were literally printed out cases of the cases from court reports, actually edited court reporting. And if you think about it, how far the law had came from those days when nobody trusted anything if it came off of a computer. And I guess we're kind of back to the future these days, because now we've got cases on AI, which are indeed non-existent.
Yeah, and at least when you're talking about those cases, they came off of legal publishers were the ones who designed those sites, right? Quick Law was a
law professor.
Queens. Right. It was a law professor at Queens, and then kind of got rolled into LexisNexis now. But but at least it was a legitimate, known product that was used, and it was accessible by the courts. The courts had access to it, so there wasn't really any issue with a fake case. The issue
they didn't believe them, though. I mean,
they just were not vetted authorities. That's why there was a concern.
Right. They weren't edited. I mean, there were the days of actual law reports, when law reports edited and published decisions. Those days are long gone. Now we all would have like a direct drive publishing, where cases are automatically uploaded now onto Canly, which is every case ever. And there's no publisher anymore. It's just automatically there.
Right. It's not
Um,
vetted.
this is not vetted by anybody other than the judge, I suppose, who wrote it and the parties. But now we're seeing, and I think in fairness, look, let's just go back to sort of some basic principles. So what we're talking about is what I'll call um, huge explosion in legal cases where lawyers are relying on authorities in argument, which is what you do if you're making an argument. You rely on this case, that case. You say this case stands for this proposition and why the court can rely on it, and you cite the cases and whatnot. But what we've seen is a huge explosion, pretty much globally, of lawyers in all sorts of cases using precedents which are not precedents at all, which are fake, because they're using generative AI to write their factums, and generative AI is not beneath just making stuff up, and it makes up cases, or it misses cases, or mixes them up, or whatever. Anyways, comes up with phony authorities, which then, because people are lazy, frankly, and I come back to that point because that is exactly what's going on here, in my opinion. Um, they put these before the court, and the courts are catching lawyers doing it, and the consequences are severe. But when I say lawyers are lazy, I don't necessarily say that as a bad thing. I mean, I can tell you that as when when our age, when legal research became automated and you could do it online, I thought it was fantastic. I mean, it was way easier to search phrases and things like that on a search engine than it was to go to a CEDs, for example, and go find the case and then pull it off the shelf. And this is just, it was, to me, it was fantastic. And I thought, in a profession that bills by the hour, if you didn't do that, you were kind of cheating the client. You should try to do things in the most efficient way possible. And I say lazy, not necessarily in a bad way, but it was much easier to use automated legal research than books. And now, for sure, it's much easier to use artificial intelligence than to actually have to read the cases.
That's true. Um, I've been a research lawyer for over 30 years now, Gavin, as you know. If you find the right book and you find the right chapter, which is not necessarily hard to find, if you know actually what you're looking for, um, uh, it's actually not that time efficient sometimes to be using phrases because you can get too many things. And at least when you go to a published book, uh, someone has already done the work and has cited the leading authorities, and you don't need all those other authorities all the time that you get
and,
now.
and put it in context.
Right,
So that you're
and they
not
put
going
it
down
in
a rabbit hole.
context. Exactly. Um, Regardless, you've got to read the case. But you're right. What is happening now is that I think a lot of lawyers, unfortunately, are taking shortcuts. They're looking for that one paragraph or two paragraphs of the decision that stand for a certain principle, which is fine. But you do have to read the entirety of the case to understand how that principle played out within the specific facts of the decision, and how, right, and whether that case is actually distinguishable or on point to the case that you're working on.
Right. But I actually think that it's more nefarious than that. I think that what's happening with AI is it's doing your work for you. And one of the things I mean, if you're like, I mean, everybody's go, I gotta go try Chat GPT and see what it comes out with stuff that sounds pretty good. Like, I mean, it really is impressive. It comes out in a nanosecond with this super polished, organized, nice headings, and you know, it looks great and reads great, and you're going, wow, this is way better than any work product I could ever do. And I think a lot of lawyers are getting sucked into that, and they're just saying, well, I'll just let Chat GPT or whatever it is, whatever. I mean, there's a number of these AI providers out there, but let them write the factum for me.
But I think with all those, look, I think there's lots of problems with all of these products coming out. People are doing tests on these products. I was just at a seminar last week on a product. I'm sure the publisher was happy that I didn't stand up and ask my question, because what I'm seeing is even their product has a 34% inaccuracy rate now.
Wow.
Right? And that's really high.
1 in 3.
Yeah, from playing in their own sandbox. And that's not good. But what I heard, and I wanted to ask the question, I didn't have a chance, is that it seems to be actually using an AI agent to help run its searches. And, as you know, and you've been on a couple of cases, this AI agent is making up quotations from real cases. And that's becoming a real problem as well, right? It's not just the fake
It's a huge
cases;
problem.
it's the fake
And
quotations.
lawyers really need to understand the huge risk that they're taking by relying on AI to do their job. You are look and that's that's just the focus of this podcast today is really a cautionary tale to lawyers, especially young lawyers. Look, I mean, the reality of it is that reputations, in the legal profession. I mean, I don't know that we live in a strange day and age in terms of what reputation is, but reputation matters in this profession. There is nothing more important to a lawyer than their reputation. I mean, their reputation with other lawyers, their reputation with the public, with clients, and most importantly, their reputation with the bench. Because if a judge doesn't trust the lawyer, you're done. I mean, you're behind the 8 ball whenever you're arguing a case in front of a judge who, for whatever reason, does not have confidence that you're going to, that they can rely on you. And that's one of the key relationships people forget about in being a lawyer is the court depends on you. You were there in a number of roles. You're there obviously to advocate for your client, but you have another role, which is you're an officer of the court. And it's a privilege to be a lawyer and to be able to appear before a court and be able to make submissions. And what it means is that out of all the people that are out there, you are considered to be someone the court is prepared to listen to and put some credence in. And you lose that, and then you have nothing.
Right. And we were talking, this really is now an ethical issue in terms of officers of the court. And what our podcast is about is you're the lawyer on the other side of the matter. You haven't used the fake cases, or you're a lawyer who is overseeing the work of another lawyer. You're trusting, and especially if it's a senior lawyer, you're trusting that lawyer's work. And then all of a sudden, that lawyer, because they decided to rely on their client to do the work, or decided to cut corners in some respects, and had the client write the brief and decided not to check, has put in a host of fake cases, non-existent cases, fake quotations, and away we go. Right?
Yeah,
when somebody catches you.
and that was a case out of Oregon where there was plenty of blame to go around. And let me put another cautionary tale out there. I mean, from the client's perspective, clients are paying lawyers by the hour. I mean, a lot of clients, unfortunately, will look at this and go, well, what do I need them for? I can do this myself on ChatGPT or Claude or whatever it is. I can write the factum. I'm not paying you to do it. I'm going to do it. And then you put your name on it,
Right.
lawyer. And a lot of lawyers, unfortunately, are okay, sure, why not? I'll rent out my letterhead and put my name on something that I didn't draft. So one of the cases we were dealing with was that we were talking about is a case called, I think is it Corvette or
Couvret, I think,
out of Oregon.
Yeah.
And Oregon has a interesting rule that they only allow lawyers from Oregon. A lawyer from Oregon has to be on the record in an Oregon case. But in this case, it sounds like the client really wanted to micromanage. They wanted to have a California lawyer on the record. So he had to enlist an Oregon lawyer to sort of be his, I don't know, his wingman, for lack of a better word. And in the meantime, it looks like, although I don't know that the facts ever came out, it looks like the client had a great deal to do with the actual creation of the written argument.
Yeah, the court actually makes that finding that the client, there was a very high likelihood that the client drafted the materials. And
Yeah.
there's like, for any listener, do a Google search of Couvret versus Wisnowski. There's a
You might
whole,
have to spell that one, or
uh,
maybe ChatGPT can spell it.
yeah, Couvret. Just search Couvret. Family winery business. There's a huge backstory in behind. Apparently the California lawyer's son was dating the client's daughter and all kinds of stuff going on. So, regardless, Oregon had some local rules, as you say, Gavin, that required an Oregon lawyer to basically, I'm going to call it, chaperone the file. And he didn't do the work. He just
Nobody did the
trusted.
work.
No, and the California lawyer didn't either. Right. No, nobody did the work other than the apparent, and then apparently the client,
Yeah.
and three
Well, I don't even
briefs.
think the client did the work. The client, I mean,
Who knows who did the work?
some robot did the work. That's the problem. The unnamed robot, who nobody caught. That's the
Yeah.
problem.
And anyway, in a nutshell, the Oregon lawyer was found to have willfully breached his local rules by not overseeing the matter, by not actually reviewing any of the documents that were filed, any of the briefs that were filed, and checking to make sure that the citations and the law set out in those briefs was actually correct. He didn't take the brunt of the fall. The California lawyer did. But still, an award was made because it was under federal court rules. The client wasn't the one who was responsible because the rules prevented the client from paying the costs. The lawyers had to pay the costs. And the poor Oregon lawyer got hit with, something like $14,500 in costs at the end, personally. And the California lawyer had to pay the remainder, which was, something like 85,000, the defendant's costs in seeking what was called in Oregon a sanctions motion against the plaintiff. They were those were their reasonable costs, and the rules allowed that to be charged to the lawyers.
So the reality of all of this is that you can't, as I say, you can't really rent out your name. If your name is gonna go on a document, you have a responsibility with regards to that document. I mean, I know that in practice, as a practical matter, it really does put an enormous amount of onus, frankly, on a lawyer. And in this situation, I have some sympathy from on a practical level for the lawyers, because it seems to me that usually what the client is doing is the client wants to do the work themselves because they don't want to pay for it. They don't want to pay for you to review the work. They don't want to pay for you to draft it, for sure. They're doing this through using AI, and then, but you really run a huge risk here. And I think the risk for these lawyers is far, far more than just the cost awards that they got whacked with. I mean, here we are, in Canada talking about this. I mean, this is going to be with those lawyers forever. This will be their legacy. Was it, oh, you were the one who put the fake case, the fake case lawyers. So it's just an absolute scarlet letter on a lawyer's reputation.
Yeah, absolutely. And, we're having a debate in our office, Gavin. There's a second case that came out of the United States that basically criticized an opposing lawyer who wasn't responsible for the fake cases that were put in a brief, but didn't review the brief of the other side and didn't even know that the other side had used the fake cases, and the matter came before the court.
Yeah.
And so
That's an
the
interesting question.
right, and
I
so the
mean,
judge is sitting there saying, "Well, wait a second. Why didn't you catch this? That's your
you
obligation."
opposing counsel.
Yeah, opposing counsel,
Yeah.
why didn't you catch it?
Yeah, like if when you get an argument from the other side with their cases, I mean, you got to read the other side's cases. You usually you want to say, oh, they don't help, they don't support the argument, or you usually you've got to read the other side's cases in order to distinguish them from the facts of your case, and or to say that they actually help you or whatever. But here, what happened was the judge was, I think, rightly annoyed because all these lawyers are getting paid, right? Presumably to put forward an argument or knock down the other side's argument, and none of them did their job. None of them reviewed the cases either that they were A, relying on, or B, that the other side was relying on. And it was left to the judge to catch the fact that the cases were not real. And the judge is saying, that's not my job. I should be entitled to rely on counsel, right? To put forward proper authority, to make a reasoned argument on those authorities, and opposing counsel. That's why we have an adversarial system. You're supposed to catch the other guy's mistakes.
100%. And the judge said, why are you basically leaving me as the last line of defense? I was at a group meeting a month ago with Justice Myers, who has made a couple of decisions here in Ontario with respect to the use of fake cases. And I asked him, is anybody there to help you in terms of catching these fake cases? And he said no, like he doesn't have a clerk. Judges here in our courts, and I'm sure in courts in other jurisdictions, they're sitting there without any help. And, they're either knowing what the law is and then recognizing at a hearing that something is not quite right with an authority, or they're having to look at it in chambers when they're writing their decision.
Yeah, I mean, they shouldn't be going to. I mean, the whole idea of a factum or written argument is to help the court,
Right.
right? With the art, this is what the case. This is the pith and substance of the case, and this is how it applies to the facts of this matter. I mean, that's what you should be. Good advocacy helps the judge and makes it easier for the judge to find in your favor than the other side. That's good. That's the nature of good advocacy. But when you have a situation where the judge is supposed to be able to rely on you, but can't because you're putting before them authority, and frankly putting them in at risk, because what if they did rely on you? What if they did just okay, well, whatever, this sounds good, I'll just put that in, and then it gets appealed, and then you're in the court of appeal, and the court of appeal will say, who's going to get castigated then? Well, the judge will. I mean, the judge will be the one who is lambasted. There was a case recently where an arbitrator relied on did uncritically, I guess, read an argument, relied on fake cases, and it was set aside immediately, the decision,
Yeah, there have
on the
been a couple
basis
of
it didn't
decisions like that.
didn't matter what else was in the decision. You can't rely on fake cases, and they vacated the whole arbitral award. What a waste of time and money, and how embarrassing for everybody involved.
Well, and who pays for that at the end of the day, other than the clients, unless, the court makes an order that the lawyer's got to pay the money back.
Yeah, well, I mean, I think what a huge waste of time,
Right.
and energy, and the courts are, I think, rightfully annoyed that their officers are not doing their job, and we are officers of the court and have a duty. Well, we have a duty. Number one duty paramount to the client. I mean, basically, if you're saying I'm relying on, Smith v. Jones for the following proposition, and there is no Smith v. Jones, and it doesn't stand for that proposition, you've lied to the court, right? You've misrepresented the law.
Yeah. Well,
And
you've breached the ethical code of conduct.
well, you've put yourself in a position where you have made a misrepresentation to the court about A, the existence of a case, and B, the proposition for which it stands.
Yeah.
So to me, I don't think people really realize that. But when your name's on it, I don't care if ChatGPT, Claude, or whatever you come up with wrote it, your name's on it, and it's not AI's reputation, and nobody's going to sue AI, and AI is not going to pay any cost awards. You are.
Yeah, until I guess AI gets sued, but they're using their disclaimers. I can tell you what did the legal publisher say? You need to check and verify. We're not responsible for anything that you use with our tools. You need to do the work.
Well, that's what you're getting
So
paid for. That's what
they're
lawyers are getting
making their
paid
money,
for.
right?
I mean, I do think it comes back to fundamental laziness. It's just easier, just like it used to be easier to do the online searches. I mean, it is easier. There's no question about it. Having some machine write your factum for you is way easier than writing it yourself.
Look, it's just another tool, and you need to know how to manipulate the tools. It's now a added feature of your toolbox, your legal toolbox. Do I want to use AI? If I use AI, I still need to use my other tools to make sure that what AI is telling me is correct.
Doesn't matter which tool you're
Right?
using.
It's just another. Right. It doesn't matter which tool you're using. You need to check and you need to actually read the case or read the statute. If you want to have it help you draft the factum and it makes you sound better, by all means, go ahead and use that if that's what you feel. You know,
Yeah, I mean, it's like
I find the style of writing to be actually a little bit weird.
I agree. I
It's
mean,
not
but
it's not
I mean, it's like
simple, but
spell check, right? I mean, using spell check. I mean, no one would say that that's. Of course, you're going to use spell check.
right.
I mean, but I think when you start to get beyond that, when you delegate your function to a machine, and I mean, there were cases. I think there was a case, and I can't remember the name of it, but I recall reading about a case where a very very expensive New York law firm um, was wrapped with this. I mean, they were caught using AI. I mean, think about that. You pay some white shoe firm, thousands of dollars an hour, and meanwhile, they're just they're putting it on it. They're having AI do their work for you, and then they're charging you for it. I mean, I always think it would be curious to see the dockets.
Well,
Um,
it's the most prominent law firm. It's, they're using AI. I think clients are kind of demanding that lawyers use AI now
I think you kind of have. I mean, in
to be
fairness, on
more
the other
efficient,
hand,
but
yeah,
you still
you
have to
kind of
check
have
the
to,
work
don't you?
product.
I mean, I do think it's like I think that it's like I don't want our listeners to think, well, you guys are in the dark ages. I think you kind of have to use all these tools. I mean, the reality of it is, if the other side is using the tools, you better be using them. It's just a function of how do you use them, and you know you better not trust them totally. I mean, at the end of the day, it's your reputation, not the machines. So sure, I mean it's a tool. Use it if it makes things better, faster. You maybe it comes up with some case and I think all these tools are going to be you have to use them, but really, if the laziness of not checking what's in your fact and not reading your own cases is just it's really inexcusable, particularly where you're getting paid to do exactly that.
I just find, Gavin, I'll be quite honest with you, thinking about this, when AI first came out, I thought, you know what, it's going to eliminate jobs because it's doing the work for us. But on the other hand, seeing all these cases now and hearing all these stories, it's almost adding costs
Oh
because,
no, it's gonna yeah. There'll be like, but then again, I mean, there will be growing pains. I mean, I think that anyone who thinks that AI isn't here to stay is crazy. It's definitely here to
oh, it's
stay.
here to stay.
These genies never go back in the bottle, and every technological advance that comes along, is going to be adopted. And if either you get on the train or it runs over you, those are your two choices. So it's just I just think that as a profession, particularly the legal profession and any profession, we really can't abdicate our professional responsibility because a machine can do it cheaper and faster. Otherwise, you kind of make yourself useless. What 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 good is a legal profession if they have no credibility and if they have no real use anymore. They're really making themselves redundant.
Yeah, and I think, Gavin, that's a a good warning or good advice to everyone, right? Lawyers on both sides. It's
Yeah.
not just the lawyer producing the document; it's the lawyer who's receiving the document. Don't be lazy. Do your job.
Words to live by. And always remember, if no one is above the law, everyone is beneath it. Thanks again, Stephen. Thanks to our producer, Doug Downs. Please rate us where you get your podcasts. Flip it over to a friend if you enjoyed it. And even if you didn't, flip it over to a friend. If we annoy you, at least we're getting a reaction. So till next time, see you later.